Hi, Steve Hansen with Hansen IP Law. I want to talk to you today about a problem we've seen a lot of trademark applicants have, and that is using a trademark as a trademark. This comes up a lot when people are filing specimens of use to demonstrate that the mark is actually being used in commerce, which is a requirement to get a registration, both for an actual use or an intent to use application in the United States. And the problem is that sometimes they'll submit a specimen and it might show the mark, but it's not showing it used as a trademark. It's showing it used in some other way. And that causes the examining attorney to reject it. We had something like this happen recently when a client came to us. They'd received an office action for a mark that was primarily the owner's last name. So it was rejected initially as being directed to primarily a surname. Now, one of the ways you can overcome that rejection is by proving that the mark has acquired distinctiveness in commerce, which means you have to show how extensively the mark has been used in commerce. So the client supplied us with a lot of articles, web posts, things like that to show the mark being used in commerce. The problem was the specimens didn't really show the surname being used as a mark. They showed it being used as the name of the company because it also was used as the name of the company. And that's what I mean by the dual function of some words and phrases. In this case, the owner's last name had two uses, both as a company name and as a trademark. And unfortunately, the articles and the web posts and things showed it as a company name, not as a trademark, and so we couldn't use it. But like I said, primarily the problem comes up when you're filing specimens of use. So you have to remember, a trademark is a word, logo, a device, or a combination of those used to distinguish someone's goods from those of others and to identify the source of the goods, even if it doesn't say what that source is. And a service mark is basically the same thing, but for services. So, the problem arises when you have a word or phrase that can have dual functions. In particular, if it can be a company name or a descriptor of the goods and services, or another one that happens is if it's the name of a software program. Those are three instances in which a word or phrase can be both a trademark and something else. And if your specimen of use doesn't clearly show it as a trademark, it's going to be rejected. So what should you do? Well, the first thing is, whenever possible, a trademark should be used as an adjective. If you're going to use it, don't use it as a noun. Don't use it as the name of the thing itself, but use it as an adjective. Like think of Nike shoes, for example, Coca-Cola beverages, things like that. Wherever possible, you want to use it as an adjective and avoid using it as the name of the good or service that it's used to represent the source of. So, in the trademarks, which are for goods, you're going to want to affix the mark to the product itself, or to a container, packaging, or to a display, or some sort of label or tag that's attached to one of those things. And that will create the association between the mark and the goods or services. The trickier situation often comes up with services than goods, because services, you're often using advertising, and the mark can appear on advertising. And for example, if the mark's a company name, you might have it on the advertising as a company name, but not in a way that shows its use as a trademark. Or if you have it on a website, you might show the word or phrase being used as the name of a software program instead of an indicator of the source of the services the program is used to provide. So with a service mark, you either want to have advertising that clearly associates the mark and the particular services that you've listed in your application, or you want to have something that shows that the mark is used in rendering the services. And a common example of that is if there's a program used to render the services so that the consumers are actually going to interface with the program, you want to show the mark while they're working with the program, like having it come up as a name on the interface that they see when they're using the program. That will help it stand out more as a service mark than as simply the name of a program, which is really a computer file often, is all the name of a program is, and it doesn't necessarily function as a trademark because it's not necessarily held out to the public as an indicator of the source of the services the program is used to provide. So keep that in mind, when you're doing when you're creating your packaging or you're creating your websites, that if you're going to have a trademark and you're going to try to get it protected, or a service mark, you want to make sure there's a clear association between the mark and the goods or services, so that it's clear that what the words that you're using are actually functioning as a trademark and not as something else, which could cause a rejection. Okay? Well, that's it for now. Until next time, I'm Steve Hansen with Hansen IP Law.